Hello, and thank you for joining us today for Stern Kessler Goldstein and Fox's Patents That Survive PTAB Scrutiny webinar, the first in our PTAB 5th anniversary series. Allow me to introduce our speakers. Jason Eisenberg is a director in the electronics group. Mr. Eisenberg draws upon his experience as a patent searcher, patent examiner, patent agent, and IP attorney to craft creative solutions for clients in a wide range of matters, including examining, prosecuting, reissuing, challenging, defending, and appealing thousands of patents at the USPTO, CRU, PTAB, Federal Circuit, and Supreme Court. Mark Riegel is a director in the mechanical group and counsels a broad spectrum of domestic and international companies in developing IP strategies and protecting new technologies. His practice focuses on prosecuting and managing worldwide utility and design patent portfolios to help his clients achieve their business objectives. His prosecution and counseling expertise informs his work in proceedings at the Patent Trial and Appeal Board, where he has handled numerous inter partes review and other proceedings. Jeremiah Fruhoff, a director in the Biotechnology Chemical Group, counsels domestic and international clients on patent procurement, product development and clearance strategies, and protection of complex worldwide patent portfolios. Mr. Fruhoff leverages his experience in numerous inter partes disputes, including district court litigation, USPTO litigation, and Section 337 investigations before the US ITC to help patent owners and challengers craft and execute patent strategies that best align with their business needs. And with that, I will turn it over to our speakers.
Thank you and welcome. This is Jason Eisenberg. And I'd like to thank you for our introductions. Yeah, give us 1 second. We'd like to break this discussion today into 3 parts, the first 2 of which we'll go through fairly quickly. We'll talk about the latest statistics and numbers occurring in terms of filings at the PTAB. We'll discuss our overview of what we'll get into in more depth, the takeaways from what we see happening both at the PTAB, at the district courts, and throughout our entire practice, and then we'll get into implementation details of prosecution strategy, increase return in view of the current state of the global IP system. What we're showing you here is a quarterly view of patent filings that have occurred in the last 5 years. We're nearing 7,000 total AIA proceedings, broken apart into the inter partes reviews, the covered business method reviews, and the post-grant reviews. What we see is the average is around the same for the last few years, which is about 150 petitions per month. And what we've delved into, which was part of a previous presentation, is are these numbers being inflated by more petitions per either by different petitioners or the same petitioners to cover multiple grounds or multiple claims in view of the scrutiny that the judges are currently placing on the petitions for institution. And what we found is that it's still a lot of unique patents being challenged by a single petition. So we don't see a very large inflation in these numbers. The bottom statistic here on this slide talks about 1.64 petitions per patent. So it's just about 1 petition per patent to 1.5. It's not an artificial inflation. So we are actually seeing a lot of new, unique being challenged over the course of even the last couple of years. PTAB. There's still a predominantly electrical, mechanical basis of the challenges, as these statistics show, at almost 80% coming in those categories, whereas bio and chemical design still have a strong presence at the PTAB. What I'd like to go over now is some high-level lessons learned that we brought out in our article on how the PTAB and the district courts and the Supreme Court, quite frankly, are affecting the decision-making at the prosecution and preparation level and determining what and how companies should go about protecting their assets and their research and development costs to build the most useful and effective portfolio that in years to come will mitigate against attacks and challenges both at the office and in the court system. The predominant side we'll talk about here is the patent owner side, just because we're talking about portfolio building. And when you think about the patent owner side at the board, you always hear practitioners discussing how it's very asymmetrical. And what we mean by that, it's not a level playing field. And that's both in terms of how much time a patent owner has and what resources a patent owner has in front of them that they can use in the pre-institution stage. The petitioner can bring forth any evidence they wish. They can spend any amount of time up to the bar date in developing that petition and bringing forth that evidence. And in the beginning, up through at least last May, the patent owner had very little chance to develop original evidence to rebut any positions taken in the petition and to allow a more level playing field before institution so that the board had more facts that it could determine whether institution was correct or not in each case. So what we're looking at is leveling that playing field by looking at original prosecution, reissue prosecution, potentially re-exam prosecution to bring forth more evidence into original patent records and post-grant records that can be used by a patent owner when challenged in a PTAB. What we're seeing is claim construction is at the core of winning as a patent owner. And that claim construction, when it becomes an offensive strategy for the patent owner, is typically based on having good detailed specifications with good sets of figures that are explained well and a lot of detail, and having terms that are unique and special or important to that claim set being brought out well in a specification and through prosecution, so that a patent owner can rely on that despite being under the broadest reasonable interpretation and use it to his benefit when a term appears broad but can be narrowed through the specification or prosecution. So we're looking at those types of defenses being brought out during preparation or during prosecution to be able to be used by the patent owner. And we're looking at how to build a portfolio of patents around a single innovation or a single invention that's coming out, where the effect on the related patents and patent applications is mitigated by reducing the estoppel that occurs through the PTAB process. And in the end, I think what we're trying to provide is the ammunition to build a portfolio that gives you a return on interest, that doesn't just give you patents that your inventors can hang on a wall, but actually patents you can enforce, patents you can license, patents you can globally use, and that mitigates against whatever may happen in the law with respect to 101, 102, 103, and 112. And from that, I pass it to Jeremiah to follow up on the next topic.
Yeah. Thanks, Jason. Thanks for the overview on, statistics and some of the broad implications for PTAB proceedings and district court and elsewhere. But what we'd like to do now is to look a little closer at the last 5 years and why procedurally and substantively we've seen cancellation of a number of patents and sort of what those factors are. And those factors lead into our discussion of how you get to building PTAB resilient portfolios. So in this slide here, we're looking at various procedural aspects that some of them, as Jason just mentioned, such as claim interpretation standards, particularly looking at the broadest reasonable standard applied at PTAB, the same you see during ex parte prosecution versus the P.L.L.C standard you see in district court and elsewhere. But there's also a number of other factors that procedurally have just, really changed the dynamic over the last 5 years, including the cost and the speed of a PTAB proceeding compared to district court litigation, the lack of a validity for the PTAB, and the preponderance of evidence standard to prove invalidity versus clear and convincing in court, both significantly affecting how a patent will withstand challenge at the PTAB. And again, as we're all aware, the judges that work at the Patent Office are technically and legally trained in the realm of patent law rather than being more generalists like in the district court. And that, of course, has led to a much more nuanced argument and filing of papers that really dig in on the details that you're not quite seeing in district court. And just this morning, affecting the last point here, the ability of patent owner to amend during PTAB proceedings is restricted. So we've seen now the In Re Aqua Products decision come out, and as we are looking to that 150 or so page decision and starting to digest it, and of course our firm will be putting out materials, alerts, we'll have training and other sorts of information coming out from that. I mean, the takeaway is it appears that there is an opportunity, a potential opportunity for amendment that might be happening now at the PTAB. But what's the real impact of that when you're looking at amending something in an inter partes proceeding compared to amendments during ex parte prosecution? Harkens back to the old inter partes re-exam dynamic, which was very challenging to get amendments through that process. And look, the substantive issues or considerations that we've seen through these proceedings, again, as Jason mentioned, several of these points, looking at the types of claims that are more susceptible to challenge and cancellation, where they're overly broad, where the claim terms are unclear, they're undefined. There are inconsistencies in how those terms are used, both within the specification, within different claims, within different families. The insufficient detail on specifications, which really is significantly more of an issue with respect to 101 and sorts of detail that you add to a specification to address that dynamic change. Boilerplate that you might just copy in that, I think really KSR sort of set the ball in motion to shy away from just adding in boilerplate when it might be used against you and your other portfolios, later filed portfolio applications. And really coming down to developing a story of the invention that works not only during prosecution, but if the invention can be maintained through the PTAB proceeding, it can be a much better position to maintain the patent against that challenge. And finally, sort of keeping costs down, always the sort of conundrum between conducting a prior art search when drafting or how extensive do you take that search, and when you don't do it, you always run the risk of prior art popping up. And of course, we see that a lot happening in PTAB proceedings. And so perhaps a new consideration is looking at that prior art again. So We wanted to cover a number of topics today. Each of these were included in our paper that came out just last month on the anniversary of the proceedings. And, really looking at the areas that we just talked about, Jason spoke to, and the procedural and substantive considerations that we've seen. I wanted to look at, several areas, including portfolio building and integrating that in all aspects, maintaining a flexible patent portfolio strategy, developing a record, because that record can and does help with not only perhaps denying institution, but helping you once institution has been, once the proceeding has been instituted. And of course, approaching the patent and claim drafting with a new complexity in mind, taking into consideration that more claims are better, they add costs, and Mark Riegel will talk more about that a little later, and then aligning your prosecution globally, thinking about what goes into your priority applications and how that might affect the type of proceeding that you will see as a PTAB and your ability to withstand the challenge. So we'll turn it back over to Jason to talk about integrated portfolio building.
Thank you, Jeremiah. What I'd like to go through in this slide, in this section, is the implementation of how to build a portfolio and patents that withstand subject matter eligibility attacks, which also brings into play how to withstand the claim definitions and claim construction you want, but we'll keep it at a more focused level of withstanding the attacks that have been going on in the courts and the PTAB under patent eligibility. And what we have determined through our review of district court, federal circuit, and CBM cases, and now some PGR cases, of what patents survive being challenged under Section 101 or patent subject matter eligibility, is that you need to start very early on in educating your scientists or engineers and educating the inventors you work with that there is a changed landscape in the IP space, and you can't get, for certain types of inventions, very broad coverage. You need to get very focused coverage, a coverage of what you're implementing, coverage of what you're trying to protect specifically. And what that means is that you need them to provide more detail as to the state of the art in the industry and what problems that the companies and the competitors and the products that you're using are running into, and why you're trying to solve these problems to make the products better. And by focusing in on this unique technical problem in your technical space and building out a description of that while you're writing the application, you're providing ammunition for prosecution to work with the examiners and obtain as broad a coverage as possible with this environment of the Alice challenges or the Mayo challenges or whatever they may be. And you provide more of a European view of the problem solution approach, more of the view that you really lead them down into your technical space, what's going on there, why you're solving a specific unique issue in that space, and you provide enough detail through flowcharts and algorithms, through structure, or whatever it may be in your industry. And after you've educated the scientists and engineers and you've taught them that this is the new environment we have to work in, it becomes the job of the patent attorney to implement that education and to really walk through the ideas with the inventors, with the companies, ideas with the business people, looking at competitive analysis and determine how you can best capture that. We're looking more and more at omnibus applications that capture a very large view of a product, and then follow on smaller claim steps so that we have this complete picture inside of a single application instead of small discrete pictures of different parts of a new system. And we feel that that's been very beneficial in helping get the applications through the office. And on top of that, leveraging all the programs that are available in the office to contact and work with examiners one-on-one to put it into the track one. We have a lot of technology that moves very fast, and this new procedure of track one that's put in place is providing startups or mid-size and even large companies to build portfolios very quickly, both nationally and globally, and to use the track one, to use pilot, use the final pilot, which we see leads to allowance without having to get into an RCE period, speeds up the prosecution, gets the protectable subject matter out there more quickly for licensing and enforcement. One of the big new developments that have occurred in the last 5 years, 6 years is a lot of new vendors that are providing a substantial amount of data for each individual examiner, for each individual art unit, for different groups, for appeal and 101 statistics, and whether interviews are effective, and to look at all of these vendors and this big data, as everyone's calling it now. Use the big data to make sure your first or second independent claim pushes your application into the right art unit in front of the right examiners. We see a distinct difference about getting an application in front of a technology-based examiner in the art unit we want it, rather than writing a broader claim or a certain type of claim that'll push it into a more general art unit where they're not as worried about the technology as they may be worried about subject matter eligibility. We can file the same application with the same claims and put it in front of an examiner that's in our technology space, and they're not going to get caught up in the fact that there's methods and operations going on that use a lot of algorithms and math. They're going to be caught up in, is this technology unique and advancing the industry? If you write too broad a claim or you wrote the wrong type of claim, it may push it into an art unit that is more focused on worrying about making sure that no Alice claims get out, worried about making sure that the subject matter eligibility is challenged, and not necessarily at whether the technology is moving forward in that space. So we're using this data when we're writing applications, when we're drafting the claims, when we're focusing what claim to put first, and how we're writing the backgrounds to take advantage of the art units that are providing our clients with the best chance of getting patents through quickly. And with that, I'm turning it to Mark Regal to talk about maintaining a flexible patent portfolio strategy.
Thanks, Jason. Yeah, this is maybe a bit of a sort of summary strategy, if you will, toward preparing an integrated portfolio. But I would break down that title maybe into two things. First of all, have a portfolio strategy. As Jason alluded to, this isn't about getting patents for the company cafeteria wall. Most companies are way beyond that, and so it's critical to have a portfolio strategy. And maybe one of the popular ways of describing a use for the portfolio is to create a patent thicket or a picket fence. No matter how you describe it, what we're talking about is using your portfolio to make life difficult for your competitors. And, you know, that takes some ingenuity and some planning and resources. But if it's successful, you can build this picket fence around an important product or line of products that could keep one or more competitors out of your space for multiple years. And you can do that in a number of different ways, but one of the most important ways is to provide varying scope of protection in your portfolio. And so it's obviously useful to have patents that are protecting multiple features and multiple products, but we need to start considering having multiple claims, multiple patents for possibly the same products and addressing it in different ways from different perspectives, different infringer types, and doing that using different claim types, whether it's an apparatus claim, a system claim, a method claim, by varying your preambles, shorter preambles, longer preambles that make the construction of that claim different and also make it more difficult to construe for the challenger, and varying the features that you're claiming in each of these individual cases. Obviously, it's important to do all of that so that you can target different infringers and multiple infringers, but all of that serves as a deterrent, because the number one move by all of these potential infringers is to get your patent into IPR or PGR, and if they see this vast thicket of cases that they would have to address, that may plant the seed of doubt in their minds as to whether or not it's worthwhile to go down that road. The next bullet is just a quick admonition that we need to be aware of creating ODP issues. The more complex a portfolio, the more related cases there are, the increased opportunity for those unforeseen circumstances or consequences. Obviously, ODP, shorthand for obvious type double patenting. All of these issues can be particularly relevant in the pharmaceutical and biotech space, where the cure for overcoming these ODP rejections from the patent office is filing a terminal disclaimer saying that you'll cut short this continuations term. But in doing so, you may be cutting off and truncating very important term for a particular pharma or biotech case. The second part of this really to unpack is just maintaining a flexible portfolio strategy. Jason mentioned all the tools that are available at the patent office to interface with the examiners and the office itself in different ways. Track 1 in particular can be a very effective tool when considering your portfolio in light of potential challenges. The AIA patent owner estoppel provisions apply where the board finds claims to be unpatentable and then prevent the owner from taking an action which would be inconsistent with that. And so if you see an IPR heading down that road, or a challenge has been filed and you have another pending case, if you put it into track 1, get claims that issue quickly, you won't be butting up against, hopefully, that patent owner estoppel provision, and you could have a stronger, more tightly focused claim pop out of that track 1 prosecution. And that goes hand in hand with the last bullet of keeping a continuation application pending. Obviously, for important families in the portfolio, having that extra case pending out there so that you can have the flexibility to do different things with the claims as different infringers come to light, or as different arguments come to light based on what you're seeing in IPRs or other ex parte prosecution. Having that case can be extremely valuable. Jeremiah, I think you're up.
I am. Thanks, Mark. So when I keep aware of the time, and of course, any questions that you might have, please feel free to send them through. We want to make sure we answer any questions you have on these issues. So the flexible portfolio strategy really bleeds into the path to patentability. So in the record that you're laying down, and I guess this sort of caused us to ask a number of questions or revisit strategies that were sort of the default, such as, for example, keeping file histories lean. to avoid discovery and district court litigation. And, you know, we sort of weighed the pros and cons of now bulking up the prosecution record, and, you know, that's part of our strategy to consider to create a patent that's going to survive PTAB scrutiny. And those pros, of course, are that, you know, if there is evidence in the record, the petitioner must address that evidence. So if you put in a declaration, if you put in swear behind evidence before, the petitioner must address that evidence. So that forces them to take away, you know, space from arguments they need to make in their petitions. And that has led to decisions from the PTAB for, you know, denial of institution based on failure to address that evidence. So it can increase the barrier to entry for a particular proceeding. And the patent owner preliminary response can as well refer to that evidence that's already of record. Of course, with the rule changes that allow evidence to come in the POPR, that may have changed, but still having that evidence of record during ex parte prosecution can be a tool and a record. So on the flip side, though, it does increase costs, and the issues during ex parte prosecution are always the same issues that are raised by petitioners that are considered during these proceedings. So it's still a careful balancing act, and there's still a tension with perhaps having a lean prosecution strategy for what you know will be an imminent district court litigation. But the thing now is to think about that more, and again, be flexible in designing your strategy and including your patentability. And, you know, really this next slide touches on many of those points, but I think sort of the last point, which is the consider having an independent, well-vetted expert for your declarations, is sort of reinforces the importance of submitting that evidence to present a barrier to challenge, and having that expert not be someone from your company, but perhaps someone from outside that you know would be perceived to be more independent, might carry more weight, particularly as it goes under the scrutiny in front of the PTAB. So in addition, looking at other aspects of building your record, you know, I guess they're all really tying together. I mean, Jason mentioned some of these aspects already, you know, harvesting, the importance of harvesting and developing inventions, you know, articulating unique technical solutions. Mark will talk about, you know, the importance of defining claim terms and having the varying, really integrated strategies to form a story of the invention that can be told in your application, can be told through your prosecution journey, and again into your PTAB, potential PTAB challenge and proceeding. You know, really, it really emphasizes the importance of having that story of the invention developed sooner rather than later. And, you know, depending on the importance of your portfolio, you know, it really, these proceedings really reinforce the consideration and the amount of effort that might need to be made in talking to management and pushing for, you know, certain things to be done that, you know, you may not normally do during prosecution, such as, for example, you know, performing experiments that, you know, are going to demonstrate surprising, unexpected results that really support the foundational inventions, and to make sure that, you know, you can differentiate yourself from the closest prior art and from your competitors, and that you have that extra evidence that goes beyond sort of the prima facie case of, for example, a prior art challenge. And, you know, that really ties into looking at additional objective indicia that can support patentability, and the importance, you know, I mean, I work in the pharma context, the importance of having sort of the evidence that comes out of the different experiments that you're doing, the PK studies, the manufacturing studies. It can all be very important to, again, building a record that, you know, will help withstand challenge. And that really ties into the next point, which is how the PTAB is treating objective indicia. And the real takeaway is that while they were very strict, they were really tying it to new aspects of the invention and not looking at the whole. This is from earlier PTAB decisions, but the case law from the Fed Circuit since then, has been pushing back and has sort of been asking the PTAB to, look at our precedent and look at the way that, you really should formulate the nexus of the claims to the objective indicia and, how you should consider that. And I think, the real point here is that you need to be aware that it will be, scrutinized by the third party. It will be scrutinized by the PTAB. But if you can put in that additional effort as you're building your portfolio, as you're building your record, we tend to see better results through that and through PTAB challenge. And with that, I'll turn it back to Mark.
Yeah, so just picking off on some of the topics we talked about, it's an important strategy to draft patents and claims that, aren't overly simplistic, that have some complexity to them, at least in some of your cases, so that you make life difficult, as we were talking about, for your competitor and the challengers of your patent. Notwithstanding today's In Re Aqua Products decision, it's my experience that amendments before the PTAB in these proceedings are rare. Board actually handling them and granting them is even more rare. But regardless of what direction that's going to go in, we know that the patent owner has the most control during regular prosecution before the examiners, that we're oftentimes familiar with because we've been before them in a number of cases. And so being focused on some of these issues there is going to help you save the day, no matter which way the case law goes. And we've talked about some of it already, varying the scope of the claims so that you have fallback positions during prosecution or in continuing applications of the family. Again, varying the types of claims, varying the types of preambles, etc. But maybe for this slide, the takeaway is for us to stop treating dependent claims as throw-ins to any application that we're drafting. Dependent claims that are properly crafted for patentability's sake and for commercial value can be, incredibly valuable when you're at some of these challenges where a broader independent claim might come down by the challenge, but an equally important dependent claim is difficult to find prior art on. And so, these dependent claims don't have to be overly complex, but for mechanical cases, for example, you might consider particular ratios of certain characteristics of elements in the claim. You might historically think that to be just too narrow. But if it's something that can be proven at infringement, once you get a hold of a knockoff or competitor product, then it is more likely something that the prior art's going to have a very high degree of difficulty showing. So really thinking about the dependent claims we put in these cases is going to increase the burden on the petitioner, making them robust claim sets, but also voluminous claim sets, because the more claims that are in these cases, it compounds the difficulty to challenge them. It compounds the cost associated with challenging them. Given the word limits of these petitions, petitioners may now require 2 or 3 petitions to go after an important patent. The next slide, this may be just one strategy to consider and maybe not applicable everywhere, but back to the issue of estoppel in these cases where the patentee is stopped from prosecuting claims that are patentably indistinct from claims that are held invalid in an IPR or PGR proceeding. it may sometimes be important to, during ex parte prosecution, have it cemented that certain cases are distinct from one another. And that can be done perhaps by invoking a restriction requirement, if you will, where you have an initial claim set that includes different statutory categories or some of the claiming strategies we were talking about, and it sort of provokes a restriction requirement from the examiner, where we can obviously file a divisional application to pursue another case without filing a terminal disclaimer. And if we reply to the restriction requirement carefully, and in some cases doing so without traverse and not arguing that certain groups of claims are patently indistinct, that can give some flexibility down the road to overcome any sort of patentee estoppel. The next slide, I guess it's no surprise that, proceedings before the board quite often on construction of the claims. And so a lot of what Jeremiah was talking about, having a very detailed record, can be important. One way to ensure a proper claim construction, or give you the best chance for a proper claim construction that's not overly broad in these proceedings, is to provide a glossary. We cited one case here where the board referred to the glossary and made note of how express it was, using the verb is. And I guess that's a good reminder that if you're going to do a glossary, and maybe you're going to choose to do it in every case, but if you're going to do a glossary, do it right. Maybe you want to talk about things in terms of examples as well, but if you want an express definition, make an express definition. Don't sort of hedge. Specification, obviously, with a glossary clearly defining claim terms, can overcome broad interpretation of the claims. We as patent drafters and patentees are tasked with being our own lexicographer, and so we should embrace that role. If we need squishier claim terms, for lack of a better term, in independent claims, for example, by all means, still have those, and you can back up those squishier claim terms with dependent claims that maybe expressly lay out a particular definition. Just hearkening back to sort of the idea of a patentability search, in many cases, having a patentability search done can help you. It can increase the value of the underlying patent that's being challenged, because you've drafted it with the art in mind, and probably the best art in mind, hopefully. And that's going to give you the awareness you need to effectively employ some of these strategies we've talked about. I think it also, while I wouldn't necessarily advise to have detailed background discussion in any application or anything like that, you can embed some of the story of the invention into the detailed description of the application. And even something like that obviously is helpful if you're filing later in a jurisdiction that has a problem solution approach, for example, but it can also be helpful here before the board in rebutting some of the petitioner's obviousness rationale. If you can point directly to the specification where you've explained, what went on at the time of invention and how the inventors arrived at the claimed invention, that's going to help buttress whatever expert testimony you're going to put in about that same topic. Means plus function claims, in favor, out of favor, in favor, out of favor. Not sure where they are right now, but it's certainly a tool to consider in at least some cases, because they can be used to trap a challenger into a flawed construction. We all know that construing means plus function claims can be tricky, and if a potential challenger disregard loss function claims in one of your claims in his petition, he or she may get a denial of institution by the board because they don't want to help out the petitioner with that particular construction. So it may not be a one-size-fits-all and perfect for every case, but it's a tool we have to consider. I think these last two slides can sort of best be summarized as, you know, with so many innovative companies operating or headquartered overseas, it's more important than ever aligning all these strategies across a global portfolio. The likelihood of the patent you're defending in proceeding before the PTAB having a non-U.S. priority is particularly high, and we all have clients where it's extremely high. And so I think we have to make sure that all of the strategies we've been talking about and others are implemented across the portfolio, especially where their priority cases are not being drafted here in the U.S. It can be particularly helpful for preventing some of these backdoor priority challenges that are brought up in IPRs and more directly priority challenges in PGRs. If we have to stretch the disclosure, if you will, based on a priority case that wasn't well drafted, we're going to open ourselves up to priority claims, priority challenges where a challenger may say that the U.S. case is not entitled to any particular priority and should not be given an earlier effective filing date, and therefore there's intervening prior art which may come into play. One way to sort of get global prosecution strategy aligned is consider having regular updates or annual presentations with global counsel to keep them educated on the latest U.S. case law and some of the strategies that are being developed at the PTAB, so that these priority cases are well drafted and meet all the requirements and needs that you're going to have while prosecuting them here. The final slide sort of kind of summarizes that in the context of PGRs as well. You know, to the extent you want to keep a family of cases or a particular case out of eligibility PGR, you may want to file an application with narrow claims at the outset, and hopefully it's very well supported by a well-drafted specification so that there's no question where the priority lies, that priority is valid, and then, for example, a case will not be eligible PGR on the strategy that makes it worthwhile.
One topic I want to add that we don't have, because as Jason covered in the slides, goes to the prosecution aspect, which we have touched on but not gotten into as much, and tying the prosecution into a good prior art search before you started. We have seen an increase in denial of institution based on 325D, which talks about substantially similar arguments, substantially similar art. And what we're seeing is that in the first couple of years, the denials went back to re-exams or litigation or other IPRs. But in the last year or two, we see original prosecution causing denial of institution. And what we mean by that is they're looking at notices of allowances. They're looking at arguments the examiner set forth that the applicants overcome. They're looking at both the references that are of record in the office actions, and they're looking at if you're just using a different patent that teaches the same exact thing that that reference taught. So the better references you put in front of the examiner, the better prior art searching you do, the better arguments and more detailed arguments you make in prosecution. The patent owner can use that to their benefit by arguing that all of these issues have already been resolved by the examiner during prosecution, and denial of institution is the only right course because the petitioner is just rehashing the same issues that have already been brought up. So 325D has been given a lot more teeth. We all know there was an informative opinion on 325D that was just issued by the office. They're showing that it's important for the petitioner to take all that into account when they're writing the petition and present their evidence now of why they aren't falling into a trap of just repeating what the examiner did.
Move on to questions, and we do have a question that came in. Is it good practice to have preferred clauses in a broader definition in the glossary as fallback, or would you rather use a dependent claim in such case? Jason, Mark, any on that?
Yeah, I don't know if there's a one-size-fits-all answer. I guess I typically avoid the preferred language and would instead give yourself those outs by, as the questioner suggests, maybe dependent claims, multiple dependent claims, but more so just in describing the embodiments in the specification in different ways. Some as examples, some that come across as definitions. That gives you the flexibility more so than a quote-unquote preferred language that could trip you up down the road.
Yeah.
What do you guys think? Anything else?
Yeah, we were part of the content guard case that used the glossary. And what won that case was that they had a specific detailed definition of what a term would mean. And when we are involved in oral arguments where we don't have that specific definition, the board tends to say, well, point me to where that is in the specification. Point me to why I need to make that argument. So if you want to keep it broader, it seems like to put the definition in a dependent claim and to get that dependent claim with its independent claim out of IPR may be more beneficial than putting it into the specification as a detailed preferred definition. If you're fine and you write quality dependent claims that cover the competitors and implementations, then that would be a very good way to do it. If you really have a specific implementation and it's the way you're going to do it, you don't think it's going to change, which is what we saw in the patents we were defending, then placing it right in the specification and giving meaning to the word that is a lexicographer type of meaning was why we were able to defend our client and get the claims out of that case. So I think it depends on your industry, how quickly the industry moves, what the competitors are doing, and whether getting some very good dependent claims with the definitions in there would be beneficial for the patent to survive, or whether there's really one way to do it and the industry will dictate that it's not going to change, then you can be your own lexicographer. So I think it depends on the individual circumstance.
I don't see any other questions popping up here on the chat feature. Anyone that has audio available, if you have any questions, we're happy to take them. And if not, our contact information is up here, and we look forward to hearing from you if you have any questions. And thank you very much for your time today.
Thanks, everyone. Thanks all.